So it's a great pleasure to welcome all of you to this meeting of the Standing Committee on Justice and Human Rights, where we will be commencing our study on Bill S-201, an act to prohibit and prevent genetic discrimination. It is a great pleasure to welcome the Senate sponsor of the bill, Senator James Cowan here. Welcome, Senator Cowan. The House sponsor of the bill, Rob Oliphant. Welcome, Mr. Oliphant. And we've also had the kindness of all of the members of the committee, of the panel to agree to appear together to allow the committee to pose more questions to all of you. So I'd also like to welcome from the Canadian Human Rights Commission, Marie-Claude Landry, the Chief Commissioner. Bienvenue. C'est un grand plaisir de vous accueillir ici.
Very pleased to have you here with us.
Action Branch, welcome. And Marcella Day, Senior Policy Advisor from the Human Rights Promotion Branch. Thank you so much to all of you for appearing. And I'm going to turn the floor over to Mr. Oliphant and Senator Cowan, whoever wishes to go first. Mr. Oliphant.
Oui. Je vais commencer. Merci. Thank you, Mr. Chair, and thank you all the members of the committee for this opportunity to appear before you, along with my friend and colleague, Senator Cowan, the sponsor of the bill in the Senate. It's funny to be sitting at this end of the table. It's kind of a great privilege, and I'm just reminded as a chair of another committee what a great opportunity it is to be a witness before a parliamentary committee. So thank you. I was very pleased and a little bit surprised when the House of Commons voted unanimously in favor of Bill S-201 and to send it here for further study. I did expect it to pass, but I was particularly pleased to have support from all sides and all corners of the House, including members of every party and the independents, including the Bloc Québécois and the Green Party. The fact that it passed unanimously in the House and Senate tells me that the groups, the individuals, the patients, the geneticists, the people in Canadian society who have been arguing for this bill and for genetic protection have made their case and have made it well, and senators and members of parliament have had an education in that process. So I'm not going to dwell particularly today on all the policy issues, though we can get into some of that, but I particularly chose that this bill would come to this committee for a reason, and that is that I sensed that the Health Committee would understand very intuitively the importance of the bill and the way medicine is changing in the 21st century, and that they would get that very quickly. However, this is a bill that does pass a law, and it not only amends two laws, but it creates a new act, and I think that it is an appropriate committee to actually get into the nature of discrimination and into the nature of the way we develop laws in this House and in this country. I want to take a moment to thank particularly Bev Heim-Myers from the Canadian Coalition for Genetic Fairness, who is the President and CEO of the Huntington Society of Canada, and her team, which has brought together a wide collection of health charities, patient groups, as well as others in civil society, CGEF, for instance, and other groups who have come together to educate Canadians and to make sure that this bill is passed. This bill is about changing the way medicine is done in Canada. 20th century medicine was a view that we had on the way we were doing both diagnostic and corrective medicine. In the 21st century, with the discovery of the human genome, we have a radically new way of having very much targeted medicine. And so an example of that is that this past summer, the gene for men with metastatic, fast-moving prostate cancer, in about 80% of the cases, was discovered. My father died of prostate cancer after a 20-year journey. His friend and colleague died after 18 months. For a long time, researchers have been looking at different cancers and understanding it that way. This summer, it was a radical shift in looking at cancer to understand that the genetic makeup of one man is different from another person, and it's not the cancers that necessarily were different. Hasn't explained it completely, that there's not 100% certainty about it, but it's an inkling for further research and changing the way that each of us will have our own health taken care of, as well as what we can do for our constituents. I don't, however, want to overestimate the genetic factors in disease. That would, I think, also be damaging to our shared understanding of the new world of 21st century medicine. there is mounting evidence that within biology and biochemical sciences, genetics is only predictive in about 5% of chronic illnesses or disease. In fact, 90 to 95% of illnesses are shaped by our environment and by our lifestyle and other things. And so for us to be actually moving the needle too far on this is also of concern, that we don't want to say that because someone has a genetic makeup, they are certain of getting a disease. That's just not the case. It is a marker, it is a helper for a geneticist, for a physician, for a clinician, but it is not the end of the story for anyone who has that marker. Some research into opponents of this disease, I think, have not understood that and not taken those into account in their tables. Le projet de loi S201
Bill S201 comprises 3 components. Each is essential to fight discrimination. Just like the legs of a stool, for example, a 3-legged stool, you need each leg. Here is each component in order of importance. The first one is the Genetic Non-Discrimination Act, which will be set out against all genetic discrimination, whether it is based on RNA or DNA. The second is the changes to the Canada Labour Code, and the third is the changes to the Canadian Human Rights Act. Each component is essential. None of the 3 can be taken out of the bill, just like you could not take 1 or 2 legs off of the stool and think that you could still use it.
Stool is the creation of a new statute, the Genetic Non-Discrimination Act. This act would make it a criminal offense for a service provider or anyone entering into a contract with a person to require or compel a person to take a genetic test or to disclose the results of a genetic test. It would also make it a criminal offense for a service provider or anyone entering into a contract with a person to collect, use, or disclose a person's genetic test results without prior consent. Exceptions, of course, for healthcare practitioners and research. The bill sets out criminal penalties, which are, I would note, yes, strong, but they are maximum, not minimum sentences. So this is a guideline. What it does is stresses the importance of this as a human right. Le texte précise noir sur blanc que la société.
The text specifies very clearly that society is against genetic discrimination. This is unacceptable behavior that will not be tolerated. The criminal penalties that are set out are quite high in order to be effective deterrent mechanisms. The bill is not taking aim at any specific sector or industry. Rather, it is aimed at rooting out a reprehensible behavior which it clearly sets out and against which it legally protects Canadians.
Commits a prohibited act. The second part, the second stool, leg of the stool, are changes to the Canada Labour Code, and it sets up a complaint procedure for those employees who work in federally regulated industry. It's part of the change about government being a good employer. And the third, and I think important but not as important as the first, is an amendment to the Canadian Human Rights Act, which will insert the words genetic characteristics to that act. Some have asked whether that alone would be sufficient, and I will argue it is not sufficient. I have been a member of a Human Rights Commission. I've been a chair of a Human Rights Commission. The onus in a human rights complaint is put on the complainant. It's on the patient who may actually be struggling. They may not have the financial resources. What the Act does ensures that the Crown is acting on behalf of the population to ensure that we have strong deterrence on this in this form of discrimination. It makes it fundamentally important for all Canadians to understand it. You'll be hearing from groups in the insurance industry who are concerned about this. We'll draw attention to the Privacy Commissioner's report that the insurance industry does not need to worry in the short or medium term We understand that. I think we would be open to amendments at the committee if you wanted to put in some kind of a review over 3 years or 5 years, whatever is legislatively appropriate, to ensure that that hasn't, in fact, changed the nature of the insurance industry. We're of the strong belief that having the best human health information will safeguard Canadians' health, will encourage them on their lifestyle issues, in their environmental factors and co-determinants, to have the best health outcomes possible. And in fact, we think this will help the insurance industry. People like you and I will pay our premiums for a longer period of time and will ensure that we have the best health outcomes. And the insurance industry, like the other countries in the world that have this kind of protection, will not face an adverse reaction. I'm going to look forward to your questions. I've got pages of notes, and so I will take that opportunity to do that, but want to thank you for considering the bill, and also particularly end by thanking Senator Cowan, who has, he's getting long in the tooth, but is still eager, engaged, and really quite wonderful on this. When he started this process, there were just over 2,000 genetic tests. And in just a few years, there are now close to 40,000, 38,000 genetic tests. He has shepherded this bill, brought it to different iterations, and has taken it through the Senate to get unanimous consent, offered it to me. I'm custodial parent of this bill, and it's a great privilege to work with him in our adoptive procedure. So thank you, Senator Cowan.
Thank you very much, Mr. Oliphant. Senator Cowan?
Thank you very much, Chair, and thank you, members of the committee, for allowing me to appear, and I thank my friend Rob for most of what he said. The crack about being long in the tooth, I'd ask him to reconsider, but the rest of it I appreciate. I've circulated a statement which those of you who are, can have a look at your leisure, and so I won't cover all of it in the few minutes that are available today, but I would be happy to return to it in the question period. I wanted to get really to the essence of it, and that is the issues. There's some concerns that have been expressed about the bill, and I want to address those. We know that this bill is strongly opposed by the insurance industry. They now have access to genetic test information, and they understandably don't want to relinquish that access. They say terrible things will happen to the industry if this bill passes. Now, I understand their concerns, but there are many countries around the world, as you know, which have prohibitions in place like those contained in S201. And the insurance industry in those countries continues and does just fine. I hope you will hear from the Privacy Commissioner of Canada. His office commissioned 2 studies which concluded, and Rob alluded to this, and I'll quote, "At the present time and in the near future, the impact of a ban on the use of genetic information by the life and health insurance industry would not have a significant impact on insurers and the efficient operation of insurance markets." And earlier this year, when the Privacy Commissioner appeared before the Senate in its study of this bill, he confirmed that his office stands by that conclusion. So while I understand the concerns of the insurance industry, I don't share them. When I balance the concerns of the insurance industry against the potential health benefits for Canadians of genetic testing without fear of discrimination, my choice is clear. When Senator Ted Kennedy, sponsored GINA, which is the American federal law against genetic discrimination, he hailed it as the first major new civil rights law of the new century. He said the bill recognizes that discrimination based on a person's genetic identity is just as unacceptable as discrimination on the basis of race and religion. I agree. Bill S201 says that it's not acceptable to put someone in a position where they must hand over their most personal information about their DNA. We have criminal penalties if someone steals a car, a computer, or a piece of jewelry. 6 years ago, Parliament passed an anti-spam law, which imposed penalties of up to $10 million for sending unwanted email. If we're prepared to legislate to prohibit sending unwanted emails, then I believe we should be prepared to prohibit unwanted access to one's genes. I understand from the speeches at second reading and from my conversations with others that the government proposes to supports amendments to the Human Rights Act, but opposes everything else in my bill. That in fact there's an intention to propose amendments to delete all of the provisions relating to the Canada Labour Code and to the Genetic Non-Discrimination Act. I'm told that the concern is constitutional, that some lawyers believe that the provisions in the Genetic Non-Discrimination Act fall within provincial and not federal legislative authority. This is an issue which was explored in detail when the bill was before the Senate. And I know that you're planning to hear from a number of distinguished scholars, including Peter Hogg and Professor Bruce Ryder, who are preeminent constitutional authorities, and I'm not one of those. Just let me say that I take issues of constitutionality very seriously. I'm satisfied, based upon discussions I've had with eminent constitutional authorities in this country, as well as our own Senate law clerk and parliamentary counsel, that Bill S-201, including the proposed Genetic Non-Discrimination Act, is constitutional as a valid exercise of the federal criminal law power, and it then therefore falls well within the legislative authority of our Parliament. There's been a suggestion as well that before we proceed, the provinces and territories need to be consulted. In fact, all the provinces and territories have been consulted about this bill, not once, but twice. Last December and January, I wrote to all the ministers of health in the provinces and territories, and then in February, the Senate Human Rights Committee, which was the committee studying this bill, wrote to all the provincial territories and territorial ministers of justice. In total, we received replies from 9 provinces and territories. Not one raised any objection or problem with the bill, either on a policy, from a policy aspect or from a constitutional or jurisdictional point of view. Indeed, several provinces expressed strong support for the bill. I've now met with or spoken with cabinet ministers in 3 provinces. Not one has raised any constitutional or jurisdictional concerns or any policy concerns. My strong impression is that this is an area where the provinces recognize the need for a uniform national regime, and that in the form of national legislation. There was a meeting just last month of federal, provincial, and territorial justice ministers in my home province of Nova Scotia. I spoke with the justice minister from Nova Scotia, who happened to be the chair of that meeting. She said that no one raised this bill, not the federal minister of justice, nor any provincial or territorial minister of justice. Now, we've seen other situations where provinces have come forward to express constitutional and policy concerns about federal legislation, including private members' bills. We know about Bill C-377 that would have repealed C-4, which is now before the Senate. 7 provinces in that case sent submissions to the Senate saying the bill was unconstitutional. So provincial governments, I suggest to you, are not shy about expressing themselves about these matters. But I've heard nothing from any province or territory opposing Bill S-201. So, and as far as I know, no one else has either. And that's not surprising. Canadians need a national solution. They need to know that if they have a genetic test at one point in their lives, they need to know that they need not to be worried that at some later time they might move to another part of the country where the rules could be different. They need to know that they will be protected from coast to coast to coast, no matter where they live. I also want to address the proposal that the bill be amended to delete everything but the changes to the Canadian Human Rights Act. As Rob said, the Human Rights Act is important, but it is a law of limited application, applying only to certain sectors. For example, it has no application to the insurance industry because the insurance industry is regulated at a provincial level. This came up, as you might expect, during the Senate hearings on Bill S-201. Let me read to you from the hearing when the then acting Canadian Human Rights Commissioner testified in response to a question from my colleague, Senator Eggleton. Senator Eggleton, what would you do if someone came to you with a complaint of discrimination on the basis of insurance that was denied them under the current law? The acting commissioner said this: under the current law, we do not have jurisdiction over the insurance industry. It's federally regulated private sector companies. So, as I say, transportation, telecommunications, banking industry, but not insurance companies. In other words, you would be protected as long as you experience genetic discrimination from your bank or your airline, but that's all. The bottom line is if the bill only amends the Canadian Human Rights Act, none of us could responsibly tell Canadians they can feel free to have genetic testing without fear of genetic discrimination, because that would not be the case. We would not have prohibited and prevented genetic discrimination as the title to the bill says. We would have said genetic discrimination is unacceptable in certain situations, but perfectly acceptable in others. Now, no one knows where the future lies, and again, Rob refers to this. No one knows what they'll be doing in a few years or even months. So this kind of protection, this kind of limited protection, would not be real protection. Indeed, I would argue, and this has been said to me by representatives of health organizations, that passing such a bill would be dangerous. And the Canadians would think that they would be protected. After all, Parliament has passed a law against genetic discrimination. But if they go out and have a genetic test, then they in fact could well encounter genetic discrimination that there's nothing that anyone could do about it. Mr. Oliphant has eloquently described this bill as a three-legged stool, and I agree with that analogy. I have every confidence all three legs of that stool will remain standing, that the whole bill will be found to be a valid exercise of the federal criminal law power. And as I've said, all the provinces and territories have known about this bill for some time, and no one, not one, has raised an objection of any kind. Will there be a constitutional challenge? Perhaps. We all know that the insurance company, as I said at the beginning, strongly opposes this bill. And they have deep pockets to launch such a challenge. But as Professor Ryder told the Senate committee, and probably will tell you as well, there will always be legal debate. We don't work in the area of certainty, but I think you can work in the realm of confidence here. And I'll conclude with this, with a quote from Professor Ryder. I'm the sort of person who will say that this is one of your most important responsibilities, to ensure that the legislation you vote for, you vote in favor of, is constitutional. I want to say in this case that I'm very confident, and I believe it would be the consensus view of other constitutional experts as well, that this bill is constitutional. I don't think you should be too concerned about the risk of unconstitutionality, because this seems to me to be very solidly within Parliament's jurisdiction. I'll do my best to answer any questions in the course of the time that we have available. Thank you very much for your attention.
Thank you. Thank you very much, Senator Cowan, and thank you for your not unconsiderable efforts to bring this bill forward. On va passer maintenant, on va écouter la commission.
We will now move to the Canadian Human Rights Commission. Ms. Landry. Thank you, Mr. Chair.
Je vous remercie d'avoir invité la Commission.
I'd like to thank you for inviting the Canadian Human Rights Commission to speak before your committee on Bill S-201, an act to prohibit and prevent genetic discrimination.
Commission to speak before your committee on Bill S-201. I would like to introduce my colleagues, Fiona Key, Counsel for the Commission, and Marcella Day, Senior Policy Advisor. We would like to leave the committee with three main messages today. First, we support Bill S-201, and we strongly support adding the ground of genetic characteristics to the Canadian Human Rights Act. Second, while the change to the CHRA will be a positive step, it cannot alone address all concerns surrounding the use of genetic information. And third, if Parliament adopts robust, comprehensive, and forward-thinking legislation to regulate the use of genetic information, it will make Canada a world leader in this emerging human rights issue. Before I elaborate on those 3 points, I'll speak briefly about the current context of genetic discrimination and human rights law in Canada. Parliament designed the Canadian Human Rights Act in 1977 to promote equality and to protect Canadians from discrimination based on grounds such as sex, age, disability, and race. Canada's provinces and territories all have similar human rights laws. Through the years, our human rights laws have evolved to keep pace with social change and with technological advances. Genetic research holds great promise and is developing quickly. It has inspired new methods of diagnosis and treatment. Some believe it will revolutionize medicine and health. But as Parliament has been examining Bill S-201, we have learned that some of individuals choose to avoid genetic testing out of fear. They fear that the very tests meant to help them may one day be used against them or their children. People are afraid of discrimination by employers, by schools, by insurance companies, because of what their gene can say about them. In some cases, parents have to decide whether to test their child, knowing that the child's genetic information will follow them into adulthood and could negatively affect them later in life. A test that could help save someone's life should not be a calculated risk. The scope of information that genetic testing can reveal about us now and in the future is extraordinary. And it goes well beyond our health information. In the future, these tests could answer even more questions. What is my indigenous lineage? Do I have a genetic propensity to be anxious, a good athlete, or a natural leader? Without regulation, the vast information contained in our genes could be used, shared, or accessed without our knowledge. The regulation of genetic information is an emerging area of law that remains virtually uncharted. Other jurisdictions, like Ontario, are considering legislation. But across Canada, jurisprudence in this area is almost non-existent. Our rights in this area are not clear. Last February, I gave my first parliamentary appearance as a Chief Commissioner of the Canadian Human Rights Commission. I spoke on this very issue and this bill. At that time, I told the Senate committee that the Commission supports adding the ground of genetic characteristics to the Canadian Human Rights Act. We see this legislative change as an important and positive step towards better protecting people in Canada from genetic discrimination. As it stands today, the Commission has the authority under our Act to accept discrimination complaints regarding genetic characteristics only and only if the complaint is linked to another ground, such as disability. Adding the ground of genetic characteristics to our Act will allow people to file these complaints without having to link it to another ground. It will make it clear to people in Canada that they have a right to be treated equally, regardless of their genetic characteristics and regardless of whether they choose to access genetic testing or share the result. This brings me to my second point. While changing the Canadian Human Rights Act will be a positive step for human rights, it cannot address all the concerns surrounding genetic discrimination. Other stakeholders and experts from across Canada agree. There will still be a clear need to address the very real and the very serious fears of discrimination raised during the Senate debate on Bill S-201. Fears about test results being used against us. Fears for our children. We believe that in order to properly address these concerns, it is going to take a concerted national approach. This brings me to my third and final point. In order to prevent harm and keep people in Canada safe, robust, forward-thinking and comprehensive laws are necessary. Doing so will make Canada a world leader in this emerging issue. We encourage the federal government to take the lead, to pass robust national legislation, to meet with provincial and territorial governments to determine how best to implement nationwide protections against genetic discrimination, to consult with stakeholders, groups, and human rights commissions across Canada. We believe this concerted national approach is the best way to ensure that Canada's human rights protections against genetic discrimination are robust, forward-thinking, and comprehensive. To conclude, I believe genetic information and genetic tests are meant to help us. But without adequate human rights protections and regulation of this information, genetic information could actually do more harm than good. Taking a test that could help save one's life should not be a calculated risk. En conclusion,
taking a test that could save one's life should not in any way lead to another risk. Genetic analysis was put in place to help us.
my colleague, I'm available for questions.
Merci beaucoup pour votre témoignage, Madame Landry.
Thank you very much for this brief, Ms. Landry, and now we'll move to questions.
So we're going to start with Mr. Nicholson.
Thank you very much, Mr. Chairman, and congratulations to all of you who have been supportive of this. This is an excellent piece of legislation. In my comments when this was before the House with our colleague, Mr. Oliphant, I said something like this is probably going to get more difficult to get something like this passed with the proliferation of information and the expansion of technology. And so this is why I think it's so important that a piece of legislation like this comes forward. As well, I agree with what our colleague from the House had to say with respect to our ability to create offences. I mean, this is something that the Parliament of Canada can do. They can take activity, and if we deem it to be criminal activity or offensive activity, that's within the jurisdiction of Parliament. That I'll be interested to hear what Peter Hogg, who I believe is coming before us here. But that being said, I think it's completely consistent. Now, Senator Cowan, congratulations again on bringing this forward. I think it's very, very important. You did make one comment that it sort of alarmed me a little bit. You said that the government may want to not have this part of the criminal code, or they may want to have amendments on that. I wonder if you could expand on that, or perhaps it might be better directed towards Mr. Oliphant. He might be in a better position to know this, but what are you hearing with respect to this bill?
Well, thank you, Mr. Nicholson, and thank you very much for your support. I obviously am not speaking for the government, and I have no direct information at all. I'm simply hearing and I'm interpreting. I think it was really what Mr. Casey said in his speech during the debate in the House of Commons, where he alluded to the government supporting the principle of the bill, but having concerns about jurisdiction and the need to consult with the provinces. And then I have heard, I've asked to see proposed amendments, and I have not been provided with those amendments. So either I'm simply relying on what I'm hearing second, third hand, that the government may be looking to introduce amendments, presumably through a member of the committee here, but I have no inside information and no further detail other than the indication I had was that while they were prepared to support, the only part of the bill they were prepared to support was the part that would amend the Human Rights Act, and I think as we're all agreed, that's simply not sufficient, and I suggest, and health professionals have suggested to me, that that would be a dangerous signal to send, because as I explained, people might believe that there is a protection out there which there really isn't.
Well, we've had a couple of experts with respect to the Canadian Human Rights Commission and human rights commissions in general, and both Madame Landry and our colleague Mr. Oliphant made it very clear that the Human Rights Act in and of itself cannot address all the concerns, and it can lead to a false sense of security for people if they believe that it is only included in there, and having it as as a type of criminal offense, or an offense of that type, would add to the support of that. Do you have a comment on that, Mr. Oliphant?
I just want to add one correction, is that, just to make it clear on the record, it's not a change to the criminal code.
No,
what
I
it
appreciate
is an act which uses the criminal
That's
powers of the federal government to do this stuff. So that's just one thing I want to get on the record. The second thing is, I think it's absolutely appropriate that the federal government moves cautiously in areas that could have some shared jurisdiction. I don't disagree with checking out the province's attitudes and ideas about this kind of legislation, because there are murky areas in anything with discrimination. I think, however, as Senator Cowan said, that we are not hearing that as a problem. And I was quite interesting for me to see the Bloc Québécois members of the House support this bill at second reading. They have a finely tuned conscience about jurisdiction that is federal or provincial. And they voted for this bill, and the same evening voted against another private member's bill because it had some treading on provincial jurisdiction. I think that if you do talk to the provinces, you'll find they're quite pleased with this piece of legislation. This actually is a robust piece of legislation that has robust powers, to the point that I think its deterrence potential is huge. And I actually hope that this does not end up in court cases, or that people are not discriminated against because people back off.
Yeah, I didn't mean to imply as an offense that it was going into the criminal code. I appreciate it's not. Madame Landry said that Canada would be a world leader if we get involved with this. But Mr. Oliphant, you pointed out that there are a number of jurisdictions around the world that are already in this, and that they haven't seen the wipeout of the insurance industry. Do you have, and perhaps you could, or perhaps Senator Cowan, you could present that to us, a number of the countries. I know in the United States there are a number of jurisdictions that are looking at there, but if you could give us a list of other countries that are doing that, would be very helpful.
He's the expert on this. What I would say is there's a range of approaches, from voluntary agreements with insurance industries, such as in the UK, which is now being tested as we speak. I was reading an article this week that it is already being looked at to say it probably doesn't work as a voluntary commitment, through to jurisdictions like the US that has a federal law and selected state laws. We have that kind of jurisdictional issue, but there are other countries that you've studied.
Thank you. What I'd be happy to do is to provide to the committee a survey that my office has provided, sort of a compilation of the various approaches that have been taken in various countries. I just give you the names of the countries: Britain, United States, Austria, Belgium, Denmark, Finland, France, Germany, Ireland, Israel, Luxembourg, the Netherlands, Norway, Portugal, Sweden, Switzerland, and then UNESCO and other United Nations organizations have made some declarations from time to time. The most recent one was in October of this year. The Council of Europe's Committee of Ministers issued a recommendation to member states, and one of the recommendations was that predictive genetic tests must not be carried out for insurance purposes. Existing predictive data resulting from genetic tests should not be processed for insurance purposes unless specifically authorized by law. So they're addressing this in a variety of ways, from strict legislation to moratoria. And as I said in my remarks, there's no indication in any of those countries that the insurance industry has suffered in any way. In Britain, as an example, we had evidence that since their moratorium came into effect in 2000 and I think it's 2001, around 2000, insurance rates have in fact dropped. Now, there's no suggestion that they're dropped because of the moratorium, but they haven't gone up because there is some protection in place.
Good, thank you again.
But I would be happy to provide that.
I appreciate that. That would be very helpful.
Thank you very much. Thank you very much, Mr. Nicholson. We're going to go now to Mr. McKinnon. Mr. McKinnon.
Thank you, Chair. Thank you, Senator and Mr. Oliphant, for bringing this to us. And thank you, Senator, for all the many times you've done this. So you spoke at some length about the jurisdictional problems, concerns, and Mr. Nicholson spoke to this as well. But since that seems to be the major thrust of the concerns, perhaps we'll stick with those. There's been concern that your attempt to change the law to provide criminal sanctions which are in the federal jurisdiction, are really a backdoor attempt to encroach on provincial jurisdiction over, say, private contracts. Would you please expound on that?
Well, I quickly confess that I am not a constitutional expert, and I think that question you should address that question to Mr. Hogg and Professor Ryder when they're here. But my understanding from my reading and my consultations with those and other officials and the Senate Legal Counsel is that this is, and Mr. Nicholson alluded to this, that there is a federal power to legislate against bad behavior. And if Parliament decides that discrimination is something that they wish to discourage, to prohibit, to discourage, and to use the federal criminal law power to penalize, then as long as they are not identifying and targeting any particular segment, any particular industry, or any particular actor in society, then that is a legitimate use of the federal power. And there are a legion of examples that can be provided to show where Parliament has done that, has stepped in to deem a particular type of behavior to be unacceptable, and using its power under the criminal law to legislate against that. There is no mention of insurance in this bill at all. There was mention of in an earlier version of the bill. I had a provision which was intended to provide protection to the insurers, who at that point were concerned that people would take genetic tests and then run out and get millions of dollars worth of insurance, something that's not happened in any other jurisdiction around the world, but for some reason they believed it might happen here in Canada. And so we built a protection in to say, well, if the provinces who have the responsibility to regulate the insurance industry, if they wish to provide this protection that for high-end policies you can ask for genetic information, the insurance industry was intended to be a help to them. They turned it around and said, you see, it's all about us. So as you'll note, that provision was taken out in the version that I tabled in the Senate after the last election, and which is the one before us now. So there's no mention of insurance. This bill does not target any particular actor, any particular player, any particular industry. It targets unacceptable behavior, no matter who does it. It just happens that we know from the research and from the anecdotal evidence that we've heard and that you will hear, that the biggest users and abusers of this information are the insurance companies, and to a lesser extent, employers. But this is not and could not be about any particular sector. If it was, then it would be cross that line. But it does not, and in my view, and in my opinion, it does not cross the line.
Thank you, Senator. That's my question. I'll share my time with Mr. Hassan.
Is there any time left?
You have 2 minutes left.
Okay, wonderful. So to the sponsors, I think Mr. Oliphant, you indicated that there was no also opposition from the provinces. I'd like to explore that further a little bit. If you're
Sure.
able to.
Both Senator Cowan and the clerk of the committee at the Senate sent letters to the provinces and territories. I believe 7 of the 10 jurisdictions actually responded either strongly in favor or neutrally. No one had a negative or adverse response to it. Some chose not to say anything. So that would be the first thing. And then moving on from that, having discussions with individual ministers of health in Ontario and Nova Scotia and somewhere else you were, we've had that reiterated. And so one of the issues, I think, is there is a kind of a wonderful flexibility in Canada in the way our Constitution works that, and I think it's partly, when I saw unanimity, particularly in the House of Commons, that tells me there's an instinct in the House to use our power to do this. That is a kind of a, I can't know what's in the mind of every MP, but I think it was, this is important enough, we should act. What the provinces, I think, are going to end up saying, and we can't determine that for sure, is we're glad they acted, so we don't have to do all of that. We may have to do some particular things. I'd like to see them insert those words in their human rights acts as well. I don't think that would be out of place as well, and it's a strong signal. We're saying it wouldn't be as necessary, but Madame Landry may have a comment on that as well, that we think there's a sentiment in both houses. We want to do this as Canadians helping Canadians.
Thank you. Sure.
I think the sense I've had, and we'd be happy to provide copies of the materials. We provided this to the minister, of course, before, and it was provided to the Senate committee. The sense I have is that the provinces, and the sense you get from the letters, is they're looking at their human rights codes, they're looking at their labor codes, assuming that this bill will pass. And they're seeing what changes they might need to make. Now, we haven't gone down and said, okay, and suggested to them the changes, if any, that they need to make at the provincial level. That's not our responsibility. But there's no indication, and let me reinforce that, no indication from any source, either written or oral or through the back door or under the table, that any province or territory has any concern and has any expectation other than that we will do the right thing and pass this bill.
Thanks very much, Senator Cowan, and our clerk will obtain from the clerk of the Senate the letters that were obtained by the Senate Human Rights Committee. Mr. McGregor.
Thank you, Mr. Chair. Senator Cowan, I'd like to just open by congratulating you for getting to this stage. You've been working on this issue for a long time, and to go through the Senate and all of the questions you've had to go through. You know, just last week I was talking to school groups in my riding and outlining the process, the very long route a bill must take before it reaches royal assent. And I think we have to respect the version of the bill that we have before us, because it has gone through all of that scrutiny in the Senate, and you've had the witnesses at the Human Rights Committee. And I am concerned, like my colleague Mr. Nicholson, that we have started to hear rumors that the government may have reservations about this bill. In fact, hearing that gives me a sense of deja vu with you two, because of what you went through with Bill C-14. It feels like here we are again. I guess, Senator Cowan, what I wanted to start with was, can you provide this committee with examples of where federal criminal law power is currently in statute, but may seem to be in provincial areas? Because I know there are examples of federal criminal law power where it's used extensively, and in some cases where it may seem to impinge on provincial jurisdiction, but has been accepted as constitutional.
Absolutely. Let me just... I'm just looking for I do have that information, I'm just looking for it.
Or Mr. Oliphant, if you can take it.
We have a list. I just don't want to be inaccurate.
While he's looking for that, Mr. Oliphant, can you just really emphasize for the committee just how important that concept of the three-legged stool is? Maybe, you know, the fact that we may have Canadians feel that they're under protection, but if we gut this bill and remove one of those legs, they in fact will not.
And you're going to be hearing from geneticists. I've been working with the geneticists from Sick Kids Hospital in Toronto on this bill, and they are talking about a real cases, clinical experience, where you've got a child presenting symptoms that could be one of two different diseases as its foundation. And there's a genetic test which will make the difference. Parents have declined half the time, parents have declined getting that test done for fear of future discrimination that that child may face. Even though they may have a 5% chance of actually getting that illness, they don't trust the system. If they sense that there is a possible discrimination, they won't get the test. The child could experience death. That's the reality. What then they would have to do is then, after that death of the child, go to the Human Rights Commission in their province or territory. That they would have to experience some experience where they're having to take a case forward to a commission after it's too late. And what we're trying to do is to say that this it's very different. And you got a letter from Mr. Howard that he copied me on, and it was kind of a stunning letter for me because he's not understanding the differences of the way human rights are rights, but the experience of those rights and the truncation of those rights have a different effect in different ways. And it's quite different on a life and death issue like this, where you can actually have a health impact that makes a difference.
Yes.
Thank you. Thank you. I'm referring now to evidence that Professor Ryder gave to the Senate committee when he addressed this point. And by way of preamble, he referred to, it's section 9127 of the Constitution, which confers on Parliament the exclusive jurisdiction to pass laws in relation to criminal law. And the leading decision on that, as you would know, is the Margarine reference in 1949, when Justice Rand held that a valid criminal law must have as its dominant characteristic the putting in place of prohibitions coupled with penalties for a typically criminal public purpose, such as the protection of peace, public peace, order, security, health, and morality. And that's the definition that's been followed. Then he goes on to talk about a wide range of statutes that have been upheld pursuant to the use of pursuant to that. And he said, including prohibitions on anti-competitive practices in combines legislation, the consumer protection provisions in the Food and Drugs Act, the now defunct therapeutic abortion provisions in the Criminal Code, Tobacco Products Control Act, now the Tobacco Act, the Lord's Day Act, the Firearms Act, recent legislation repealing the Long Gun Registry, the Young Offenders Act, now the Youth Criminal Justice Act, the drug offenses in the Controlled Drug and Substances Act, the toxic substance provision in what is now Part 5 of the Canadian Environmental Protection Act, the prohibition on issuing false prospectuses in what is now Section 400 of the Criminal Code, and the prohibited activities provisions in Sections 5, 9 of the Assisted Human Reproduction Act.
Thank you for that, Senator Cowan. I think that's a great list to read into the record. And then quickly, because my time is almost up, can you tell, for the benefit of the members of this committee, has the Canadian Medical Association taken a position on this bill, and what is it?
Yes, the Canadian Medical Association has taken a strong position in support of this letter, of this bill. There was a letter submitted to the chair, or sent to the chair on November 1. Chair, is that being circulated, or how is that handled at the committee?
I imagine it's being translated right now, and because I haven't seen it yet, but as soon as it's translated, it'll be circulated to the members of the committee.
Well, perhaps I could just read the concluding. I could provide copies here, but the concluding sentence to the letter signed by the President of the Canadian Medical Association is, to that end, the CMA urges the Standing Committee on Justice and Human Rights to support the enactment of Bill S-201 with no amendment.
Thank you very much.
Thank you very much, Mr. McGregor. We'll now go to Mr. Biddle.
Thank you so much, Mr. Chair, and I want to again echo my colleagues. Thank especially Senator Cowan for your incredible work on this, and to be at the forefront of an advancement in human rights is an exciting thing to be part of. And you touched on it briefly, Mr. Oliphant and Senator Cowan, but can you explain your motivation behind this bill and what really drove you to sponsor it, be a custodial parent, if you will, and to bring this forward to the Senate in Senator Cowan's case?
When the people spoke in 2011 and sent me home to Toronto, after a brief but very good time in the House of Commons, I was appointed, hired to be President CEO of the Asthma Society of Canada, a small but mighty health charity. And I was fairly quickly elected to the Governing Council of the Canadian Health Charities Coalition. And that is the group that the 30 or so health charities and patient groups in Canada are members of. And we look at particular policy issues that are stumbling blocks or barriers for us to moving or advancing the health of Canadians. At our coalition, we made the decision to get into the area of genetic testing. That with the discovery of the human genome, medicine was changing every day. And our old laws were not keeping up, our old practices and everything about our world in healthcare was changing. Now, they have not yet discovered the asthma gene. I think they've discovered biomarkers to recognize why different medications don't work. They used to do it by trial and error. Until a couple of years ago, everything was trial and error in the area of asthma. We now have biomarkers that tell people why certain medications work. In other diseases, like this year, they discovered the gene for cystic fibrosis. Several years ago, a few years ago, they discovered the gene for the genes that are related to breast cancer, ovarian cancer, cervical cancer, now prostate cancer, multiple sclerosis, Alzheimer's, rapid onset, early advanced Alzheimer's. They now have a genetic component for that. And so as a patient organization, we found that the government none of the governments in Canada were moving more quickly on this. So we looked at the American model, we looked at another model in Europe and said, let's do this. And that's when Bev Hein-Myers, one of my colleagues, started working with Senator Cowan on this bill. And it seemed a natural fit for me to pick it up because I'm not a lawyer, by God, there's a reason I'm not a lawyer when I read that list of acts. However, I understood the bill. I understood it from the health perspective. And what I was hoping was the lawyers would give us a break. That was my goal on this one, to say that the health impact of this is so important and that people's lives could be affected to the positive, that it's important. One of the stories I got were that companies were now looking at, it wasn't so much life insurance being the problem, but are you going to hire someone who carries a gene when someone else doesn't carry that gene? Even though they might have a 5% chance of actually developing that disease because of all the other factors, and we now have documented cases of employers choosing one person over another because of the experience of providing healthcare benefits or drug benefits. That's not the way we work in Canada. We share risk. We work together on that, and that is pervasive. And I would say that is a fundamental principle that we're trying to engage in.
Oh, I thought it was to both. That's
handing it off to the long in the tooth colleague. Well, I don't. Three times. I think 3 times.
Exactly.
I think, Rob, to come to the Justice Committee and say that you're glad you're not a lawyer that's not a very good way to say your case. I'm proud.
Say age is a prohibitive ground of discrimination under the Canada Human Rights Act.
Exactly. I'm proud to be a lawyer, and I'm proud to be before the committee.
Absolutely. And obviously, we need to add lawyers as a ground of discrimination too at some point.
Exactly. Anyway, seriously, I first was aware of this issue in 2011 when Barbara Cadgeson, who's with me now, and she's really the godmother of this. If he's the adoptive father, Barbara's the godmother of this case. But she drew that to my attention, and I was astounded. I couldn't believe that we wouldn't have protection in Canada for this kind of thing. So as I looked into it, you then begin to talk to folks, and I had the same experience Rob did. The more you talk about it, the more you hear every time I speak about this. Somebody will contact my office, call me, and say, well, let me tell you my story. And I'm sure you will find, as you are identified with this issue over the next few weeks, people will start to call you and tell you their stories as well. So it's that kind of personal, and it was those personal stories, I think, that really motivated me, that drove me to do what we've done over the last few years.
Final short question, Mr. Biddle?
Very short. You mentioned that you heard from the provinces. In their responses, did they highlight their own current or anticipated regulation of insurance contracts?
Well, I would say that generally what they were saying is, they appreciated they were aware of it in many cases. They appreciated being advised. If they were not aware, they were talking to their human rights commissions. They're talking to their labor folks to see what change, and the sense seemed to be that we're looking at it to see what changes we need to make at the provincial level to complement what's being done at the federal level. And certainly, as you know, there was a bill presented in the Ontario legislature within the last month, and it was made very clear at that time by the sponsor of the bill that the purpose of the bill was to bring the Ontario Human Rights Act in line with the anticipated changes to the Federal Act. So I would think that the underlying tone of the correspondence that we received, both I received and the committee received, and the conversations which I've had and others have had with provincial authorities, is that they're looking to tweak their provincial regulations, their provincial legislation, to complement what I hope we will be doing at the federal level.
Thank you very much. We're going to now go to the second round of questions. So we're going to start with Mr. Fraser.
Thank you, Mr. Chair. And I would like to echo the comments from all sides. Senator Cowan, thanking you for all of your work on this important bill and bringing it forward to this stage. And Mr. Oliphant, thank you very much for bringing it forward through the House and getting it to this stage so that we can study it. I appreciate that. My first question is for you, Madame Landry. With regard to a point made earlier by Senator Cowan, that only changing the Canadian Human Rights Act with regard to genetic discrimination, if we only change that element, that it may give some Canadians false confidence that their rights would be protected. And I know you mentioned that it's only one aspect that could be changes through the Canadian Human Rights Act, and there's other elements that we would need to look at. Would you worry as well that there could be ramifications of false confidence that Canadians may have in genetic testing if only that part was changed?
It could be, for sure. And I would say that, and I said that before the Senate committee, Canada actually is far behind in terms of protecting the discrimination from about genetic discrimination. And we should not think that it's just about discrimination. It's about health and security for person. And we need to have, as I mentioned in my speech before, we need to have a robust bill to make sure that that protection will be there. When I mentioned that Canada could be a leader for me, we have actually the chance to have a big transformation in this country and have a bill who will address what we call multifacet of the situation and have a comprehensive bill about genetic discrimination and protecting this genetic discrimination. And I don't know if, Marcella, you want to add something?
Unless there was a follow-up question?
No.
I could just add that human rights law in Canada is shared jurisdiction. Therefore, whatever changes made to our acts cannot affect those elements that are regulated provincially. It cannot have that reach. Whereas the other powers that are envisioned in the first part of this act this bill before you, can indeed have that reach across the country. We certainly encourage, regardless of what act is changed, an examination of human rights codes across the country and the addition of genetic characteristics to all human rights codes. And we believe that will flow as part of the normal course of action, as we're already seeing in Ontario.
Thank you very much. That's a helpful answer. Senator Cowan, I'd like to drill down a little bit more into the elements of the bill that deal with the criminal law power, in particular the proposed offenses and punishment. It mentions that it's a hybrid offense, that an indictable offense would have a maximum, and you correctly identify that it only outlines, of course, maximums, the worst offenders in the worst circumstances, $1 million fine and/or 5 years imprisonment on summary conviction, a $300,000 fine maximum and/or 12 months imprisonment. Of course, one of the key fundamental principles of criminal law is deterrence, both specific and general, in order to deter people from committing offenses. So I'm wondering if these are similar punishments to other countries that have this sort of prohibition, and how those offense punishments were arrived at. What thought was given in arriving at those offenses for indictable or summary?
Well, I would say first of all that it is a question of deterrence, as Rob said earlier, that's what we're trying to do. It's not so much collecting the fines or putting people in jail as it is deterring people from what I think we all agree is unacceptable behavior. So I think, Mr. Fraser, we did look more at Canadian comparables, sort of what was happening here, and we could certainly again provide you with the comparables. But if you take, for instance, I think I mentioned this in my opening part. In 2010, we passed C-28, which was the anti-spam legislation. And it imposed penalties of $1 million for an individual or $10 million for a corporation. And here, as you know, the maximum is $1 million. So we felt that this, it has to be large enough so it's significant, but yet comparable. And in terms of the imprisonment, there are a whole range of sections in the criminal code that provide for sentences up to 5 years. I'll just give you a smattering of them. Section 338, defacing a brand or mark on cattle. 394, unlawfully buying or selling valuable minerals. 397, falsifying a book or document. There are 3, 6, 8 or 9 of them there. Then there are a number that are higher. 10 years. There's, for instance, you can get 14 years if you counterfeit or mutilate a postage stamp. 10 years for insider trading. Fraudulent manipulation of stock exchange, 10 years. Stealing or forging a credit card, 10 years. So we looked at it and said, well, we need to, this is serious. We think it's very serious. So we wanted to make the potential, the maximum terms of imprisonment and the maximum fines significant. But we did have regard to what is already in those kinds of criminal cases.
And I suppose with regard to specific deterrence, having a maximum of that nature would allow repeat offenders, in order to punish them and make sure that they don't keep doing it, to have an adequate deterrent for that specific offender.
Yes. And there's no minimum penalty here.
Right. Thank you.
Thank you very much, Mr. Fraser, and thank you very much, Senator Cowan, for being the first to mention cattle at one of our meetings. It's very much appreciated. I know many of our Western colleagues will be very, very happy about that. Mr. Falk.
So don't ask me for anything.
Good. Thank you to all the witnesses here at committee today. I found your testimony and your comments very interesting and enlightening. And of course, from a Conservative side, we voted in favor of a legislation, not only just to bring it to committee and study it, but I think in principle we're in favor of it as well. As technology advances and there's progress made on lots of different fronts, different people want to use the benefit of that technology for different purposes, and I think when that happens, we have to also create the proper safeguards that prevent its abuse. And yet we want to be able to use that technology for good purposes, and I think this piece of legislation seeks to address the potential abuses. I am a little bit intrigued with something Mr. Fraser brought up, and that's that the punishment seems to be a little bit industry specific. Like when you mentioned the anti-spam legislation and the monetary penalties there, specifically targeting internet companies and companies that would use that medium as a source of advertising, and that seems to be drawn there too. I'm wondering from an industry perspective though, do you see any benefit at all for genetic testing that could be an advantage to people?
Where do I begin? Thank you. That's an excellent question. I think that is at the root of it. I think it is that's the motivation behind this, because we see this genetic testing as a key to the personalized medicine or precision medicine that is recognized, I think, by healthcare professionals as the future of medical care. Put it this way, that when you go to your doctor, and the doctor diagnoses a condition, an illness, prescribes a medication, and that is a medication which is for the average person who happens to be average male, because that's the way they test it, average male with that condition. Whereas if the medical professional were to have access to your precise genetic information, then the prescription could know, in prescribing, she or he could know which medications are most likely to succeed, and as importantly, which medications are almost sure to fail. Here's a startling statistic that I heard just a couple of weeks ago in Vancouver. I'm told that there are between 10 and 20,000 Canadians who die every year because of adverse drug reactions. Astounding figure. But what happens is that many people are prescribed drugs based upon the general information, and they adverse react. There's a syndrome called the long QT syndrome, which it's a mutation which appears in the general population 1 in 2,500.
Can I thank you for that and ask you another question, which
Absolutely.
I also want to get in?
Can I add one thing? Just one thing.
I'll provide the information to you.
It is other question, and then maybe you can add.
I really want to make sure I get. When I go to purchase insurance these days, they do a variety of medical tests on me. They do an EKG, they do a blood sample. What would be the difference in your mind between a genetic test affecting their risk rating?
I think the answer to that, where I would draw the line from a public policy point of view, is the insurance companies have access to that information about your current situation. They ask you about your historical medical information. They ask you about your current information. What hospitalizations you have, what drugs are you taking now, do you drink, do you smoke, they weigh you, they do all those kinds of things. The difference between that and the genetic test results is that genetic test results indicate to a greater or lesser extent, with a greater or lesser accuracy, what might happen in the future. And so I think if we are, as public policymakers, to draw a line between what is reasonable to provide to somebody who is assessing risk and what is across the line, I think the proper place is there.
I'm not entirely disagreeing with you, but I'm subjected to blood tests and EKGs and chest compression dimensions, all kinds of things now already that help them risk rate me, and these are current situations, right? And they check my pulse and my blood pressure and all these kinds of things. And I'm just wondering why you see that as being significantly different to do a genetic test.
Well, I think the difference is that what that blood test will give you is an indication as to your current situation. Is there, are there elements that are out of whack in your blood count? I'm really going beyond my ken here, but they'll tell you, they'll assess your current state,
okay.
And they also have access to what's happened in the past.
Okay.
A genetic test is a predictor with a greater or lesser accuracy about what might happen in the future, and that's the difference.
Okay. I really want to emphasize that part because of the predictive nature, and this is in some of the actuarial studies that were done when they were insurance industry was opposing this, did not take into account behavioral changes that could improve a person's health if they have the genetic test.
Sure.
And what was happening is we all have and I was a pastor for 25 years. One of my jobs was to encourage people to go to the doctor because they didn't want to get bad news. And I'm saying we need to lower the barriers that is a human instinct to not want to get bad news.
Right.
That's what we all have at a base level. If you also have a potential discrimination in another way, you can't get a job, it's another thing.
Thank you very much, Mr. Chair, and I recognize you're extending me some grace here. So, Madam Landry, thank you for coming. Thank you for your testimony. I'm just wondering, have there been any current complaints on genetic testing discrimination?
Sorry, can you repeat it?
I can't
Just
talk French,
you're
but I'll talk
far.
slower.
Yeah, you're far.
Are there any current complaints made to the Canadian Human Rights Commission on genetic discrimination? Have you had any cases?
As I mentioned in my speech, in fact, actually, people can complain about the situation if it's linked to something else, as disability. And actually, we have around 20 file inquiry or complaints about or can touch the genetic discrimination, but it's related to something else also, and disability, race, or...
I think what Mr. Falk is asking is, have you had to reject complaints because they didn't tie to another prohibited ground? So you basically...
If it didn't rely to another ground, for sure.
But have you had ones you had to throw out? That's what he's saying, that they've come to you, but you said, no, we can't deal with it, because that's what he's trying to ask you.
Yeah, and the answer is yes, if it doesn't link to something else, has disability or race or...
And it has happened?
Yeah.
Yes.
Yes.
Okay.
Okay, merci beaucoup. Now we're going to go to Ms. Khalid.
Oh, did you want to add something? Okay.
Please.
Thank you. I can just add a little bit more detail to that. Because genetic characteristics is not an enumerated ground in our legislation, individuals do not file complaints on that basis alone. Therefore, the complaints and inquiries that have come to us are almost always linked to another ground, because people recognize those other grounds on the face of the Act, and genetic characteristics then becomes a complementary piece to that. People are saying, I have the genes for this race, or it was just discovered I have the genetic marker for this disease. So they have indeed been connected to other grounds in our Act. I cannot say that there has been one that we have rejected specifically because it was only based on genetic characteristics. But as the Chief Commissioner mentioned, if a complaint were to come that only cited that ground, unrelated to any of the other grounds, we would in fact have to reject it as the law stands today.
Yeah, I think we know. Thank you. Ms. Khalid?
Thank you. Thank you, Chair. And thank you, Mr. Falk. Thank you, ladies and gentlemen, for coming in. I have two questions, basic, I hope. So, the current bill, S201, it doesn't define what genetic discrimination is. And it's my understanding that the previous version of the bill did define it, and the Human Rights Commission had recommended that the definition be removed, and that it be left to the tribunal and to the courts to decide how to interpret it. So my question is, why is that? And secondly, would it be beneficial at all, or would it be detrimental if parliamentarians were to set a baseline from which courts, tribunals, and in reality our provinces can also work from with respect to setting what genetic discrimination means?
So thank you very much for the question. Overall, and through the period where we have been asked to comment on our Act, we have remained steadfast that we do not recommend definitions be included in the Canadian Human Rights Act. One of the reasons for that is that Canadian human rights legislation, as with all human rights legislation, needs to be interpreted broadly in order to give effect to the underlying purpose of the Act, and that definitions are often limited in the time that they are prepared, especially with a topic like genetic characteristics, which is very rapidly evolving. That rationale becomes more important, that we would not want to freeze a definition in time where the science and technology is developing. It also allows for judges to bring that judicial interpretive principle to play when individual cases arise. So we very rarely, in fact, I can't recall a time where we recommend that a definition be added, but that does not mean that we cannot offer, for example, guidance and clarity on the concepts that are covered under our Act. And in fact, in the legislation you have before you, there has been a section which deems discrimination based on a genetic test as discrimination based on genetic characteristics, and those kinds of clarifications can assist in interpreting our Act. I hope that's helpful.
Thank you. now, a lot of forms of, well, most forms of discrimination are protected within our Canadian Human Rights Act, as well as various other statutes. And the courts have said that that these various statutes are given quasi-constitutional status. Now, this bill, it creates a specific act for a specific form of discrimination. You know, with its own set of penalties. Do you have any concerns with elevating one specific type of discrimination over others?
I can start. Yeah. Thank you again for that question. Certainly, we are not unfamiliar with legislation which has both criminal sanctions attached to it and similar protections under human rights law. For example, sexual harassment is an issue that can be complained about to the Canadian Human Rights Commission, but if the same incidents also make up a sexual assault, then a criminal action can be made on that same incident. So that kind of complementary legislation is not unfamiliar. We are always concerned with a hierarchy of grounds under the Canadian Human Rights Act. So we don't want one ground under our Act to be subject to different rules than any other ground. But because this legislation creates a separate process than under the Canadian Human Rights Act, it may not have that same effect. We are open to further examination of those issues, and we hope that the committee would look at those as they are with other issues under the Act. But the very fact of there being a multiplicity of venues, including the Canadian Human Rights Act, is not unusual where Parliament has deemed that a certain type of behaviour, which is more precise, needs to be raised to the level of protection of health, safety, or security of the person that gives a need for criminal sanctions.
Thank you. Thank you very much for that. Mr. Oliphant, Senator Cohen, if I may, did some provinces or territories highlight the need to coordinate with federal efforts with respect to the specific type of discrimination?
No. No, in fact, it wasn't. I think if that happens, it's going to be, we should promote that to happen for complementary. Member of Provincial Parliament Mike Call in Ontario has his private member's bill, which he has said complements ours, but right now that is sort of accidental. We're hoping that it isn't accidental, that we actually did it more intentionally, but right now I think that is also to respect the provinces who desire not to do it. We can't have it both ways. We can't be doing something that, some people could say it's provincial and then tell them to do something. This is a modeling exercise, and so we hope to model good behavior at the federal government level, and other provinces and territories might see that as something they could do as well.
Thank you. That's it. I have no more questions.
Mr. Cooper.
Mr. Chair, and thank you to the witnesses. In particular, it's great to see Mr. Oliphant and Senator Cowan. We spent so much time on C-14, but anyhow, I want to commend you, Senator Cowan, and Mr. Oliphant for putting forward this legislation. I mean, it is a fact that Canada is the only jurisdiction in the G7 without legislation to protect individuals against genetic discrimination. And certainly this will go a long way to closing that gap that exists. I want to just ask Ms. Laundrie, just to follow up on Mr. Falk's question, just looking at the Canadian Human Rights Act, I was a little unclear as to whether there have been cases that have been dismissed. I know, for example, if you look at the Canadian Human Rights Act, it's one of the prohibited grounds of discrimination is disability. So has, for example, disability been interpreted in the context of genetic discrimination? And if so, what have the outcomes of those cases been?
Thank you for your question. There are no decided cases on this issue under the Canadian Human Rights Act. There was a case that originated in Quebec that went to the Supreme Court of Canada where an issue related to genetic characteristics was recognized by the court and linked to discrimination on the basis of disability, so that has been recognized in the jurisprudence. To go back to your initial question, which was whether or not the Commission has dismissed a complaint or decided not to deal with a complaint on the basis of genetic characteristics, as my colleagues explained earlier, because the Act currently does not list genetic characteristics as a prohibited ground of discrimination, we do not collect statistics on that particular form of discrimination. If a complaint comes to us and names a ground of discrimination that's already in the legislation, for example, disability, we would deal with it on that basis. But if a complaint comes to us solely on the basis of genetic characteristics, we would not deal with it and we would not report it.
Could I add to that? And it's because I have a very low-level experience of this, working in an office with human rights complaints. What typically happened in the territory of Yukon would be a phone call would come in on something, and the receptionist starts actually doing triage and screening, and it might get to an investigator, but if it's not on the list of prohibited grounds, it doesn't even get, it gets logged as a call, but it doesn't get analyzed because it's not on one of the prohibited grounds. So we don't have that data. Would like to have it, but that's the way the human rights system, and because I have very low-level experience, they have a high-level experience, I know what it's like to answer the phone even. So it's
and the case that you're referring to, Ms. Keith, was on the basis of the Quebec Charter. Is that correct?
Correct.
Yeah. And I think that was on the basis that handicap is in the Quebec Charter, and the court ruled on that basis.
I believe that's the language in that legislation.
Yeah. You know, one of the things that is troubling is the fact that in Canada today, really people are penalized for proactively undertaking testing that could be very beneficial to them over the long term. Now, Mr. Oliphant, you had referred to the fact that not only are people being penalized, but in many cases that they are frankly afraid of seeking this testing for fear of discrimination. And I think you referred to something at Sick Kids Hospital in Toronto. Would you maybe care to elaborate a little more? And maybe Ms. Laundrie, if you might want to add to it, because I know you alluded to that.
I have to ask for a brief answer from Mr. Oliphant, because then we have to get to Mr. McGregor. We're going to get kicked out of the room shortly. So if it's okay with you, Mr. Cooper, I'd just like Mr. Oliphant to answer.
I think Dr. Ronnie Cohn is one of your witnesses, maybe?
Yes,
I think so. And I think you'll get a better answer from Dr. Cohn than from me, because he'll have exact, and I've met with him now 5 or 6 times about this issue, and I think he can give you exact scenarios of the way that plays out in both his research work, where people don't want to even get into research projects for drug tests, because it now involves those kind of tests. So we won't have new drugs coming into the market because people don't want to do that. And then we have in the clinical practice a physician who is arguing with parents to say, please get the test so I can do my job, and they step back. The other thing in Canada I just wanted to get on the record is, not only is this about the health of Canadians, and that's my primary thing, but there are emerging industries, biotech industries, that Canada can be a leader in. I've talked to people from 2 companies. One is Sequence Bio in Newfoundland, which is a world leader on biotech information. They're going to do a survey of 100,000 Canadians. They are desperate to have this information so they can do that testing. They feel they won't get a sample size big enough if they don't do it. And in Quebec, it's Biogenique is again another company. So these are jobs, and these are important issues that we need to also address.
Thanks. Just because of time, Mr. McGregor? Yes.
Okay. So a very quick question, Senator Cowan. I've read the Senate transcripts as your bill made its way through there, and you certainly encountered a fair number of your colleagues who were skeptics on the constitutionality. Just your thoughts on what it was you think that led them to overcome those doubts and stand with you to send that bill to this House.
Well, I always hesitate to speak for others, but my sense would be again that we provided to the Senate, as we will provide to your committee, strong evidence from eminent constitutional scholars that this is a legitimate exercise of the federal power. And I think the responses from the provinces, both to my inquiries and from the committee, indicated that the provinces are not concerned either on a jurisdictional or a policy point of view, and they're looking to they'll examine their own codes and legislation to make it complementary, but they're not saying, hold on, we need to act first. They're waiting for federal action, in my view, and I think that's our responsibility.
Well, technically you have 2 more minutes.
Okay. I guess, yeah, the other point I wanted to get across was, you know, sort of following up on what Mr. Falk's question was, you know, nothing in this bill is going to prevent or hamper the provinces from legislating contractual law with insurance companies if they so wish. I would venture that both of you would agree with that. But also the fact that, you know, in this new era of medicine, we really are on the dawn of a new age of personalized medicine. It may be that if we are taking away the fear of people to get a genetic test, we actually encourage that, you know, more healthy lifestyles, people taking control of their own destiny, so to speak. And it may, in the long run, save our health system thousands, if not millions of dollars, and in fact may even save the insurance companies some money as well. Would you agree with that?
Absolutely. The thing about targeted, and I've avoided the word personalized medicine because it kind of sounds high-end store. It's targeted medicine, and so you don't waste time doing trial and error getting to better health outcomes. You actually give information that people can change their lives. The famous case is Angelina Jolie. The famous case of a person who dropped her risk from over 90% down to 5% of developing breast cancer. That gives her the opportunity to live a full life, pay more insurance premiums, do all those things that she's going to do. And it's normal, average, non-star people as well can have that. It can have that impact, and it's hugely important that we drop any barrier because it's so human to not want to do that. That if there's something artificial in that way or it's legal in that way, let's get the barrier down.
Thank you so much. I just want to thank all of the witnesses for coming forward today. Your testimony was greatly helpful to our committee. And since there's another committee coming in, I'd ask everyone to clear out as quickly as possible. Meeting adjourned. Thanks.